What's up, guys? Brian Fell Law Group PLLC here with your Florida Law Weekly case update. It's almost 5 o'clock on a Friday. It's 5 o'clock somewhere, so I got a 5-pack of cases for you this week. First one is out of the 2nd DCA, Fernandez versus Kivimaki. And this one has to do with modification of alimony by an oral agreement. Can you modify alimony by an oral agreement? A lot of times we see in our MSAs, our marital settlement agreements, we'll see a provision that says this cannot be modified unless it's in writing, executed with the same formality as the MSA. Well, that's important because, like here in this case, the former husband and the former wife apparently agreed orally through their daughter to modify his alimony obligation from $1,100 a month down to $600 a month, nearly in half. And so the former wife was saying, well, you know, it's not a real agreement, not a enforceable oral agreement. She was saying that it really didn't even exist, but she was a little equivocal on that. Anyway, the trial court found that there was a valid oral agreement to modify, and the appellate court affirmed that. So be very careful with your clients. Tell them, make sure, don't do anything that would make it seem like you're agreeing to something orally. Don't do anything like accepting payments without making it specifically clear that I'm not agreeing to modify, something along those lines, just to be absolutely sure. Next case is Chavez versus Department of Revenue. This is out of the 3rd DCA. This one is important for anybody who gets one of those Department of Revenue letters asking to calculate child support, and then they provide their financial information voluntarily, but they do not ask for a hearing. If you don't ask for a hearing on that, you cannot appeal. It's really, really important for people and for clients to understand that, because that's what happened here. Somebody, apparently they voluntarily gave their financial information to the DOR. DOR calculated child support, and then they tried to appeal. They didn't ask for a hearing, though. And the appellate court said, hey, you didn't ask for a hearing below, so sorry, you cannot appeal it. So that's a tough one there. Make sure you ask for a hearing in those kind of cases. Next case is out of the 1st DCA. It's Lavinder versus Bryson. And this one was somewhat interesting. It was a enforcement of an Alabama judgment, and it had to do with alimony, again, modification of alimony, and basically an enforcement of alimony. Former wife was trying to enforce former husband's alimony obligation. Former husband was saying, hey, former wife is actually receiving part of my Social Security income, so that should be credited against her, and so I shouldn't have to pay any more alimony. The trial court actually agreed totally with the former husband, and not only said that former husband didn't have to pay any arrears, couldn't be held in contempt, but also terminated the alimony obligation. The appellate court said that went a little too far, so they shouldn't have terminated the alimony obligation, particularly because there was no pleading or anything asking for termination. But the appellate court affirmed the trial court, saying, hey, if the former wife is receiving Social Security benefits on behalf of the husband, that can be used as a credit, and he doesn't have to pay alimony, doesn't have to pay his alimony obligation. It's key here that the court was applying Alabama law, so I wonder if this would be the same result if they were applying a Florida law. Maybe not. I'm not entirely sure on that, but that was interesting. So Social Security can cover alimony obligations, at least in Alabama. Next case is Campbell versus Jara. This is out of the 2nd DCA. This one I thought was interesting because it had to do with imputation of income to a father who was allegedly voluntarily underemployed. So this guy was only working, I believe, 25 hours per week at his job. And according to him, that was all the time that the job allowed, or allowed him to do, was 25 hours per week. And he apparently, this father used to drive Uber or some sort of ride sharing, but he no longer does that. And so the trial court imputed income to him, so saying basically he could work 40 hours per week. But the appellate court reversed. And so this is really big for people that are trying to impute income for alimony or child support purposes. Basically, not only do you have to present evidence that the failure to work, the underemployment, is voluntary. You basically have to show, like, why. Why is it voluntary? You can't just say, well, he's only working 25 hours per week. Was it because he was taking care of the children? Was it because he was, doing other things, going to medical appointments or something that he had to go to, which I believe is what he was saying here. He was taking care of the kids and going to medical appointments. So, or was he just literally like doing nothing and he could be working? So you really have to present evidence on what the person you're trying to impute income to, what was he doing? Why was it voluntary that he wasn't actually working the full 40 hours in the week? So that's something really good to remember. Last case is a case where they certified conflict to the Florida Supreme Court. It's Julia versus Ramos-Baez. It's out of the 6th DCA, the new DCA, relatively new. And so basically they said this had to do with attorney's fees. So what's the main thing that everybody knows to put in your attorney's fees order? The number of hours expended and the reasonable hourly rate, right? And also some other Roe factors, Florida Patients Fund v. Roe. But it's always been ingrained in our heads. You have to include the number of hours spent and the reasonable hourly rate. Well, this judgment had neither of those, didn't have anything. But the person appealing did not present a transcript of the proceedings below or any substitute for a transcript. So 4 other DCAs apparently relying on this one case, going back a while back, rely on this case for the proposition that those findings have to be in writing. They have to literally be in the judgment or else gets reversed, like automatically, has to be in writing. Well, the 6th DCA said, wait a minute, there's really no requirement in Roe or nothing in the law, absolutely nothing in the law whatsoever is what they said, that requires that those findings have to be in writing. The trial court could say, for example, make them, during the hearing, make them orally during the hearing, and it could be on the record if you had a transcript. And so the 6th DCA said basically, well, it's the person who's appealing, it's their burden to provide the transcript, and since they didn't provide the transcript, hey, too bad, too sad. And they said, look, there's nothing in the law that mandates that these findings have to be in writing. So hey, we're going to affirm. They certified conflict with 4 other DCAs. So we'll see what happens. We'll see if the Supreme Court takes it up. All right, guys, that's it for this week. Hopefully you guys had a decent week. It's been a tough week for me, but that's okay. We're moving forward. See you guys next week. Take care.